Wills versus living trusts. A comprehensive comparison planning for the future is a cornerstone of sound financial and personal management. Among the essential tools in estate planning are wills and living trusts, both of which help dictate how assets will be managed and distributed after death. Although these tools serve similar overarching purposes, they differ significantly in execution, flexibility, costs, and legal implications. This article explores the key differences and similarities between wills and living trusts, providing a thorough comparison to help individuals make informed decisions about their estate planning needs. Definition and purpose. A will is a legal document that outlines an individual's wishes regarding the distribution of their assets, the care of minor children, and the appointment of an executor to oversee the estate's settlement process. Wills take effect only after the death of the individual and must go through probate, a court-supervised process that validates the will and oversees its implementation. A living trust, also known as a revocable trust, is a legal arrangement in which an individual, referred to as the grantor, transfers ownership of their assets into the trust during their lifetime. The trust is managed by a trustee, who can also be the grantor, for the benefit of designated beneficiaries. Living trusts take effect immediately upon creation and allow for the management of assets both during the grantor's life and after their death, often bypassing probate. Execution and flexibility. Creation. Creating a will involves drafting a document that specifies how assets will be distributed after death. It typically requires witnesses to sign the document to make it legally valid. Setting up a living trust requires drafting a trust agreement, transferring ownership of assets into the trust, and designating a trustee and beneficiaries. This transfer process is essential to the trust's functionality. Flexibility. Wills are relatively straightforward to modify through codicils, amendments, or by drafting a new will. However, changes take effect only after the individual's death. Living trusts offer greater flexibility during the grantor's lifetime, as they can be amended or revoked at any time. Additionally, they can accommodate scenarios like incapacity, providing a seamless mechanism for asset management. Probate and privacy. Probate. A will must go through probate, a process where a court validates the will and supervises the distribution of assets. Probate can be time-consuming and expensive, often lasting several months or even years. Assets in a living trust bypass probate, allowing for quicker and more private distribution. This can save time and reduce legal fees. Privacy. Wills become public records during probate, meaning anyone can access the document and learn details about the estate. Living trusts remain private, as they do not go through probate. This makes them an appealing option for individuals who value confidentiality. Costs. Initial setup. Wills are generally less expensive to create, with costs typically ranging from $300 to $1,000 for a basic will, depending on the complexity and the attorney's fees. Living trust. Living trusts require a more significant initial investment, often costing $2,000 to $10,000 or more due to the complexity of drafting the trust agreement and transferring assets. Long-term costs. Although cheaper upfront, wills can incur significant probate costs, including court fees and executor compensation, which can deplete the estate's value. While costlier to establish, living trusts will at times save money in the long run by avoiding probate fees and minimizing administrative expenses. Incapacity planning. Wills do not address incapacity. If an individual becomes incapacitated, the court may need to appoint a guardian or conservator to manage their affairs, which can be a burdensome and invasive process. Living trusts are highly effective for incapacity planning. The designated trustee can step in to manage the trust's assets immediately, avoiding court intervention and ensuring continuity of asset management. Control and management. A will only dictates asset distribution after death. It does not provide any mechanism for managing assets during the individual's lifetime. A living trust provides ongoing management of assets. The grantor can serve as the trustee while alive and competent, retaining full control. Upon incapacity or death, the successor trustee takes over seamlessly. Tax implications. Wills do not offer any tax advantages. Estate taxes and inheritance taxes apply as dictated by federal and state laws. Living trusts generally do not reduce estate taxes but may facilitate more efficient tax planning. Trusts can be structured to incorporate tax-saving strategies, such as bypass trusts or charitable remainder trusts. Dispute potential. Wills are sometimes prone to challenges during probate. Common grounds for contesting a will include allegations of undue influence, lack of capacity, or improper execution. Living trusts are generally a little harder to challenge because they take effect during the grantor's lifetime and involve ongoing management. This makes it more difficult to argue the grantor lacked capacity or was unduly influenced unless done just prior to their passing. Suitability and best use cases. A will is generally best for individuals with modest estates who do not anticipate probate to be particularly burdensome. Suitable for addressing guardianship of minor children, as this cannot be done through a trust. Ideal for straightforward asset distributions without complex conditions. A living trust is usually ideal for individuals with larger estates or those who own property in multiple states, as it avoids multi-state probate. Suitable for those seeking privacy and efficiency in the distribution process. Beneficial for those concerned about incapacity and wanting a streamlined plan for asset management. Conclusion: wills and living trusts are both valuable tools in estate planning, but they serve different purposes and meet different needs. A will is simpler and less expensive upfront, making it a good choice for individuals with straightforward estates. In contrast, a living trust offers greater flexibility, privacy, and efficiency, making it ideal for complex estates and those concerned with incapacity or avoiding probate. Ultimately, many individuals benefit from using both a will and a living trust in a complementary manner. A pour-over will, for example, ensures any assets inadvertently left out of a living trust are directed into it upon death. Consulting with an experienced estate planning attorney can help determine the best approach based on individual circumstances and goals. By understanding the distinctions between these tools, individuals can take proactive steps to secure their legacy and provide for their loved ones.